Excellent. So I'm going to look at automated copyright enforcement on platforms, designing autonomous global norms, sort of as posing that as a question. And as Oles mentioned, it's a paper which I have already been giving 1 or 2 times, and there's this underlying research paper which some of you may have seen on SSRN, but that's work in progress. And the broader question which I'm interested in the role of platforms and where and how we should respond to platforms setting by means of private ordering norms which kind of operate on a global level, which affect many users across the world. So that kind of question, I think, is pretty much open, at least for me, and therefore I'd be very interested to get views on that particular issue. So in terms of what I want to say or address, I guess structure the presentation in 2 parts. The first part is focusing on a particular type of private order. So when I say private order, I mean rules set by private actors, in this case platforms, in particular YouTube, and YouTube's mechanism to enforce copyright. Or in fact, as you might see then in our discussion, it's actually not really that comparable to copyright after all, because the way that works is significantly different from how copyright law operates, for example, in the UK, in other jurisdictions as well. But even if you use sort of the international copyright regime as a benchmark to compare the YouTube system against, you would probably still find significant differences. And I'm going to focus on one particular aspect of that copyright regime on YouTube, which is automatically enforced through a system called Content ID. And that is how there's been a very strong emphasis on monetization of user-generated content. So UGC here on that slide stands for user-generated content. And that's an interesting aspect, I think, and also where there's going to be one reference then or one comparison to the current attempts in the European Union under the Digital Single Market Directive to address this whole sort of value gap debate about the power of platforms to benefit from user content and whether that is unfairly perhaps preventing creators and content owners to monetize content. And so that's going to be one reference to this current legislative attempt. Otherwise, I'm going to focus pretty much on the private orders set by the platform itself. And I'm going to then ask the brief sort of question, and that's certainly something I'll be interested to discuss further. What follows from a regulatory copyright perspective? So if we've got these private actors like platforms setting out these private orders, how should we respond? Should we respond at all? And so on. And can we respond meaningfully on a national level, right? But then again, I mean, is it realistic to assume that there's going to be some sort of an international agreement addressing these things where states can't really agree on many things these days internationally? And then the second part was going to look at how this form of automated content protection, again, the YouTube example, but perhaps more broadly, norms being set by platforms on the internet as the new normal, as the main norms rather than state-set norms. And that, I guess, to some extent, although I'm not an expert there, would apply to dealing with hate speech, dealing with child pornography, and dealing with other issues, freedom of expression and so on, where effectively, even though maybe induced by state regulation, the norms actually being applied to us online are norms set by private actors. That's my experience so far. I'll be happy to discuss that further. And that then, of course, raises the core question, what follows for the role of platforms? How do we address platforms? And again, that's not something, not a new question, of course, but I think also a question where we yet haven't found any good answers. So I've got about 25 slides on all of this. I'm probably not going to be able to address everything in detail because I promised Angela and Oles to finish in around 25 to 30 minutes, and I'm already 5 minutes into what I was meant to discuss. But of course, we can, in the Q&A, then discuss certain aspects further. So if I'm sometimes a bit brief, then that's in order to get most of the aspects into the presentation. Right, to start then with the first part about monetizing user-generated content. And this is sort of just a bit of background for those who are perhaps less familiar with copyright law online and the importance of intermediaries, platforms like YouTube, Facebook, TikTok, Instagram, and others. They effectively, of course, in terms of business model, live on users freely sharing content, mainly in exchange for the data generated in the process. And most of that user-generated content actually is in a way based on or involves elements of appropriations or reuses of existing copyrighted material. And then, of course, that raises the question of whether that requires an authorization by the copyright owner, or whether that perhaps because the material maybe fall under, or the use of the material may fall under certain types of copyright exceptions, might not otherwise meet the threshold for infringement and so on. So that there may be a lot of cases where there isn't copyright infringement under any particular domestic law, but there may still be quite a few cases where user-generated content potentially does infringe copyright. And that being so, platforms then, as the one mediating that content, allowing users to share it, to look at it, and so on, or maybe even actively promoting, if you think about TikTok, for example, users to upload stuff, and YouTube, of course, as well, then these platforms have to consider under what circumstances they might be liable for the infringements, the instances where users infringe copyright. And then, as you probably most of you will know, there's this default under the so-called safe harbor approach, be it the USDMCA, be it the European Union e-commerce directive, which, as I understand it, nowadays is currently being revised. Now, that these approaches effectively are based on the idea that once a platform effectively takes certain steps to prevent users from accessing infringing content, if they are being notified of infringements on their platform and they take it down, this notice and take it down system is a sort of default position, I'd say, where platforms can avoid liability. So that's the basic status quo, removing or blocking infringing content once being notified. And then, of course, there is, with the EU's Digital Single Market Directive, an approach to modify that. I'm not going to get into the details of that, but it's, broadly speaking, an approach which tries to expand liability of platforms and, under certain circumstances, hold them liable for the content which users share on their platform. But despite that, or even before that, significantly before that, in the case of YouTube, basically since Google bought YouTube in 2007, platforms have taken quite proactive steps to monitor and filter allegedly copyright infringing user-generated content. And in the case of YouTube, that's by means of YouTube's automated system called Content ID. So in a nutshell, by the way, I'm happy to share the slides later on. If you then run the slides in presentation mode, you can click on these things, the link here, which would, for example, get you to the Content ID webpage. And there's a short YouTube video, as you might expect, explaining what Content ID is. So in a nutshell, that's a system where YouTube enters into contractual arrangements with large copyright owners. Doesn't do so with everyone. In fact, if you had 1 or 2 uploads on YouTube or otherwise content online which you fear might be utilized by other users on YouTube, you probably wouldn't get access to Content ID unless you're represented by a major label or other sort of online digital rights management or organization. But those who do or who are in a position to enter into these contracts with YouTube, they're then allowed to basically submit to YouTube reference files for all the digital content they claim to have rights on, copyrights essentially, or neighboring rights. And then YouTube puts these reference files into a huge database. And whenever you upload something onto the YouTube platform effectively, then automatically that upload is being compared to anything in the database. And YouTube is quite good nowadays in also making sure that slight modifications of original content are still captured. So it has quite so sophisticated filtering technology in this regard. And if you think about it, these sort of, mechanisms of content ID, they can be seen as private orders because they affect everyone on the platform. They're therefore transnational in reach, they're automatically enforced, and they have, as we will see in the case of YouTube, and in the case of, I suppose, Facebook and Instagram, which use similar mechanisms by a service provider called Audible Magic. They have inbuilt, dispute resolution systems. So that's sort of already getting to one of my points I want to make later on. If you think about it, you have the rules here. You have administration, so the rules being sort of legislative in that nature. You have an administrative element, how the rules are being applied and enforced, and you have an adjudicative element as well. So if you think about sort of what constitutes a state in terms of its three main functions, you have legislature, adjudication, and administration in one on that platform, within the limits of the platform, of course. And then one of the questions which I got interested in initially was, okay, why would a platform like YouTube invest so much, in the case of Content ID, over $100 million into developing and fine-tuning and improving these tools like Content ID? Is it to, prevent liability? Is it to cooperate with right holders? Well, maybe some of these things, but also, and that's because when you use especially Content ID and when you see how it's been operated, it pays out huge amounts of money to YouTube. So they benefit from being able, through Content ID, to monetize user-generated content. So how does it work? So the basic there is that, of course, as some of you might know, you as an individual user can monetize content on YouTube if you get, if your channel has over a particular threshold of followers, and if you get a certain number of hits on your individual videos. But there's another form of monetization which works through Content ID. And there the basic idea is that those who claim copyright protection in relation to any of users' uploads, they effectively then are the sole entity benefiting from that user-generated content, regardless, by the way, of how little that say copyrighted part is in relation to the whole video of the user. That's at least the most recent sort of implementation of that private ordering by YouTube I'm aware of. But I must say, last time I checked this like 2 or 3 months ago. So unless YouTube has changed that, that's probably still going to be the case. And the kind of policies you as a Content ID owner or copyright owner on YouTube can set in relation to your individual copyrighted content is to say, well, you want to monetize it, you want it being tracked, or you want it being blocked, right? And most of the debate in copyright law has been on blocking, or we don't want platforms to filter and block content. But in fact, if you look at it, as you can see from the figures I'm going to show you in a moment, the very vast majority is actually not about blocking, at least when it comes to music. It may be somewhat different in the film sector, but maybe COVID is also going to change that, because distribution models and commercialization models in the film industry probably also going to move increasingly online rather than to theaters and so on. So it's essentially about monetization. And therefore, that's, I think, one of the key reasons to understand why platforms like YouTube have a significant self-interest in these mechanisms, because monetization means usually 50% roughly for YouTube. I think it's, in fact, slightly more usually, and somewhat less than 50% for the ones owning or claiming rights in that content. And the default of the system, if you don't, as a Content ID operator, copyright owner, if you don't change it in relation to individual copyrighted materials you own, is that the monetization model is going to be applied, and that's going to be applied throughout the world. So If you look at figures then, and this is from a piracy report from Google, so Google owning YouTube, that of course includes YouTube and includes discussions about Content ID. And first thing to note here is that almost all copyright issues on YouTube are handled through Content ID rather than a sort of more manual, if you want to call it that way, notice and takedown process, for example, under the DMCA. And within Content ID, again, almost all claims are automated. You can manually claim on Content ID as well, but let's leave that aside because it's just a very tiny fraction. And then if you look at all this sort of, if you focus on the amount of copyright issues dealt via Content ID in an automated way, where again, 90% of all that is focusing on monetization. In the music industry, it's actually 95%. And that monetization has effectively paid out over $3 billion to rights holders over a couple of the last 5 years, I think. In the last annual period, YouTube discusses in this report, and that's the most recent one I could find. I just checked online before this talk. It's the one which relates to the period of September 2017 to September 2018. And in that period alone, the Content ID system has paid out to right holders $1.8 billion in revenues. So that's effectively a huge licensing mechanism. And YouTube gets the same amount out of that, because my understanding is that YouTube more or less gets 50% of a cut here. And as I mentioned earlier, one, I think, problematic aspect here is that any amount of content claimed allows the claimant to monetize the whole video. So imagine you have like a 15-minute video, and that includes a tiny snippet of something which potentially is copyright protected and claimed by someone. The monetization of the video as a whole will then be in favor of that entity who has claimed that tiny fraction. So, and that's something YouTube has been saying it's going to work on, but that isn't yet apparently the case, at least to my knowledge. Okay, then just one example very briefly for those of you who maybe want to follow this up. There's this sort of meme which went viral on YouTube a couple of years back, the Harlem Shake. And that's sort of basically loads of videos of people acting, dancing rather crazy to a particular music. And the meme was something someone in New York developed on the basis of music which was sampled by a DJ. Bauer is his name, the second video here in the line. By the way, if you click on this one here, it gets you to one of these videos. But otherwise, of course, just Google that. Now, and here in a piece which I recommend reading for those who have an interest in this, it's more social science piece. It's about monetizing this particular meme. The main argument authors are making is that this only was allowing the owner in the copyright or claiming the copyright in the music to monetize all revenues resulting from all these different videos based on this Harlem Shake meme. And that entity was able to make a couple of million US dollars on that basis. So what follows? So you have a regime which one might say, well, it's based on users in the terms of service to YouTube when they upload material. They generally accept that they are giving YouTube a license to utilize the material. So it's basically all covered by the terms of service by YouTube. But because it significantly changes, I think, the status quo in various ways from how copyright law would otherwise operate, I think we need to ask the question whether we would necessarily want to allow platforms to deal with user-generated content in the way they are dealing with it in examples like Content ID. And I think the argument that, for example, well, you including copyrighted material potentially that being infringing, that I think, of course, still doesn't necessarily provide, at least under the traditional paradigms of copyright law, a sufficient justification for the claimant in that content to monetize the video as a whole, right? If it's just a tiny fraction, for example. And another aspect, of course, is that YouTube doesn't really check whether the claimed content is in fact copyright protected and who actually owns it. All of that is effectively up to users to effectively dispute, and the default is that the system, but because of its the way it's automated and because the power it gives to the entities being able to use these automated tools of filtering and then monetizing or possibly even blocking, it kind of puts the onus on the user to rectify things, which I think in a way is problematic. All right. So just here one brief side note on the Digital Single Market Directive. I think that in a way misses the point when in Article 17, Section 7, just in a nutshell, Article 17 is about sort of dealing with the value gap debate and dealing with enhanced liability of platform under certain circumstances. And it has in Section 7 a particular set of rules trying to protect users against overblocking and overfiltering. But I think in a way it's somewhat missing the point, because at least if you look at Content ID, and I think, although I've not done the research, but I would be surprised that whether if it would be otherwise on platforms like Facebook or Instagram, blocking isn't really the main issue. The main issue is monetization. And therefore, we should more carefully think about how we need to give users perhaps a sufficient share in the benefits, commercial benefits arising from that monetization. And if you look at the text of Article 17, Section 7, you see that this mainly focuses on blocking. Although the second aspect, where it's about enabling users to rely on existing exceptions, like quotation, criticism, review, or caricature, and so on, you could say, of course, also cover situations where users would rely on these exceptions in order to prevent others to monetize without their authorization, their content, right? So if you do a video and that effectively includes copyrighted content, but it's seen to be a parody, for example, then of course, relying on your parody defense or exception would also in principle allow you to prevent others monetizing your video without your consent. Okay, so here I think the key question for me, which I love to discuss with you guys further, is how we can reconceptualize copyright exceptions and other copyright limits if it's not about actually preventing blocking or in the real world barring injunctive relief or requests for damages, but about sort of sharing the benefits which can be derived from monetization. So that's one of the questions. And then moving, I guess, within 5 minutes or so, because looking at the time, I think I should finish within more or less 5 minutes. Looking at the aspects of platforms or the role of platforms in all of this, and again, using perhaps Content ID as one example, but also giving other brief examples about how platforms intentionally or perhaps sometimes unintentionally have global reach in how they affect users and society as a whole. So in an earlier discussion I had about this with people here in Cambridge, one of the fellows at Wolfson College, and John Norton, his name is, I think, coined the term functional sovereigns in order to describe platforms. So I think that's a way which brings in these ideas about platforms at times acting almost equivalent to states. But of course, sovereignty there doesn't essentially relate to territory or to a people, but it relates to the function of the platform and its services and how it's operating online. But I got a few examples indicating perhaps that this is quite a widespread phenomenon if you look at the major platforms. And here just to point to a range of instances where the content ID system is fairly broad. I'm not going to discuss that now in detail here, but if you think about regular copyright law and you think about what it covers, the kind of exclusive rights it provides, the exceptions, identifying ownership, and so on, lots of these aspects, although in quite different forms, are addressed on content ID. And I think that's something I address in somewhat more detail in the paper. And so coming back to this idea of legislation, administration, judiciary, and I haven't really discussed, haven't had time to look at the dispute settlement system on YouTube, but looking at that, for example, discussed somewhat in the paper, you'll see that there is a mechanism which again, however, I think unfairly disadvantages users. So nevertheless, I think one of the things looking at these broad private orders, I'd say, is that it gives the impression that platforms like YouTube operate equivalent to states within their functional domain, right? So within their domain, they act as states. And now I've got a few examples just to show you, and that's now beyond copyright, how far-reaching influences of platforms can be. Most of that is not going to be new to you, but it's just sort of perhaps worth reminding ourselves of that. And that's sometimes unintended, and at times, of course, it's an intentional, deliberate response to requests from society to act in a particular way, that, you know, to take down child pornography, to prevent hate speech, and the measures which are then taken. I'm not criticizing the measures in their substance. I'm just using them as examples to show that eventually what counts is what the platform does. Of course, often that will be informed by what the platform is required to do. But of course, then again, it depends on, well, whose domestic law is it that the platform implements? And if you look at the content ID system again, you'll see that content ID, although there are certain differences in how right holders can set their policies, in principle operates, as far as I've seen it, the same across the globe. And it's somewhat modeled around the US DMCA in terms of when the dispute settlement system kicks in and how it addresses this. Okay, so the other question then is, if like platform policy is based on a response to state-made laws, well, whose laws is it that the platform is responding to? So one very brief example is about YouTube again, and how YouTube has, at some point in time, a couple of years back, changed its algorithm to focus instead of hits, in terms of what kind of videos it suggests to other users. It focuses on the amount of time others have spent on watching a video. So rather than someone just clicking on it for once and then sort of skipping the video after you know, you see that it's not really interesting, the algorithm would rather suggest things to you which others have watched for a prolonged period of time and spent the, like, you know, longer minutes or even hours watching it. And that had the unintended consequences of boosting in the rankings on YouTube videos with right-wing content, right? And that's just one example of these unintended consequences, how people have been dragged into right-wing content because they all of a sudden were promoted significantly more on YouTube. And that's, you know, an article in the New York Times, which was here on this slide, if you click on that line, which I think nicely summarizes some of these points. Another point is the use of WhatsApp in the Brazilian election, and the fact that certain devices, electronic devices, mobile phones primarily, but maybe other sort of, you know, devices as well, in developing countries or low-income countries, when you purchase a device, it has pre-installed certain apps, of course, but not only are these apps pre-installed, but they also allow you free access to the internet. So if you want to get free access to the internet in Brazil, you know, you can, for example, use WhatsApp, and you can use a range of other services, but for other things you might have to pay. So that means that especially people who can't afford that will be on WhatsApp. Bolsonaro used that very deliberately to launch a huge misinformation campaign on WhatsApp, and that arguably has led to, well, not probably his sole reason, but one of the reasons for his election. And that's an approach to which you see similarly across the globe, right? These sort of somewhat unintended consequences of tying a particular platform with free internet access. Now, then there's, of course, also instances where, and I'm finished in 1 or 2 minutes, I suppose, where platforms deliberately respond to calls from society or lawmakers. And for example, Twitter's CEO announcing that Twitter will stop political ads was something which was seen in the whole context about fake news and deliberate campaigns to misinform about the US election. And you see a contrary response on Facebook where Mark Zuckerberg was saying, well, you know, we don't want to, in fact, be the one who makes decisions about whether a political ad is or is not fake. So we leave that, and therefore we're not stopping political ads. And Instagram then, as another example, at some point in October 2019, for example, to remove self-harm content, and Instagram, of course, defining what it considers to be self-harming content, which is meant to be removed from the platform. And again, this sort of creating certain drawbacks because self-harm survivors arguing that they weren't able to tell their stories anymore on Instagram. And then a somewhat telling example where Facebook launches its own Supreme Court. They don't dub it that themselves, they use another term. But if you look at the functionality of that body, which is, of course, not completely independent from Facebook, but it's meant to, again, I think, create some sort of an image of Facebook allowing a somewhat independent and fair third party to look at whether and to what extent its own policies harm freedom of expression primarily. That's, I think, another instance where you can compare the behavior of these platforms to some extent to sovereigns. And just very recently, of course, that's yesterday, Trump being banned from Facebook indefinitely, although his Twitter account apparently is back up, right? So, and again, I'm not too concerned about the substance of these decisions. I think it's more about that making these decisions has this significant impact. And then the key questions for me, which follow from this, is how do we look at intermediaries? And to what extent do we allow, based on notions of private autonomy and freedom of contract, the relationships between intermediaries and users to be governed solely by private orders, i.e. by whatever these platforms put into their terms of service, and to what extent we can meaningfully take into account these transnational and inter omnes effects where platforms effectively, in my view, act as functional sovereigns.